My name is Will Carmody, and I'm the Managing Partner of Mason Hayes & Curran, and it is my great pleasure to welcome you all here this morning to our 2023 Data Privacy Masterclass. Our last Data Privacy Masterclass, of course, was held online in 2021 in the depths of COVID, so it's really great to be back here in person, in the in-person format. Great to hear the chatter and the networking and the talk in the room earlier on this morning. Today's event is particularly timely, given that last Thursday, excuse me, the 25th of May, marked the 5th anniversary since the GDPR came into force. The technology sector is a really important one for our firm, but also for Ireland Inc. If you work in this sector, whether you're an in-house counsel, a software engineer, a data protection officer, or an AI developer, you really have your work cut out to stay on top of all the developments in the legal regime that governs it. The law in this area is particularly dynamic, from regulations pouring out of Brussels to the Digital Services Act, the new AI Act. We've guidance notes being published by the DPC practically every other day, and new judgments being handed down from the courts of justice in the EU, not to mention the incessant media coverage in this whole area. So it can be really, really hard to keep on top of it all. As we all know, some of the biggest, most of the biggest digital platforms in the world by market capitalisation are based in Ireland. And because of GDPR's country of origin principle, there is one organisation that's been kept really busy keeping up to date with all these developments, and that's our own Data Protection Commission. In March 2022, a report that they published revealed that over 22,000 complaints had been lodged with the DPC since the GDPR came into force, of which over 20,000 have been concluded. And the same report revealed that 61% of cross-border complaints handled by the DPC as lead supervisory authority were originated with another supervisory authority and transferred to the DPC. So with all of this activity, it's really clear that Ireland and the DPC is right at the crossroads of this discussion about data privacy, which has ramifications for the global technology industry and for economies well beyond Ireland's. Even though we're here this morning to discuss data protection, the legal regulation of technology isn't confined to that. In the last few years, there's been a raft of new Irish and EU laws regarding online content, and in particularly the Digital Services Act. And in that context, just want to mention as well quickly that on the 13th of June, Mason Hayes & Curran is hosting another seminar, this time with Ireland's new Online Safety Commissioner, Niamh Hodnett. And that's going to discuss the new Media Commission's first work plan and also the development of binding online safety codes. This will be of interest, obviously, to any technology company that's dealing with user-generated content, and you're all more than welcome to attend that conference as well. You'll get the details by scanning the QR codes that are around the room and just clicking on the event section of our app there. So now, back to this morning's business, and let me hand you over now to Philip Nolan, who's partner and head of privacy and data security with our firm, and also Oisin Tobin, head of our technology sector group, and also a partner in our privacy and data security practice. They are the subject matter experts here now this morning, and they're going to guide you through some of the key developments in data privacy over the last 12 months or so. So over to you, gentlemen, and thank you very much.
Great. Thanks very much, Will. For those stragglers at the back, there's some seats at the front if you're brave enough to come up. Anyway, look, glad to see a full house. We weren't sure if the weather would work in our favour or not, and it seems to have got everyone up early and into the marker. So delighted to see you all here. As Will said, after it's been a couple of years since we had you all here in person. Questions. There's questions going both ways today. As Natalie said, you all have the opportunity to ask us some questions using the Slido app. Natalie explained how that can be accessed using the QR code. We also have questions for you, just to make sure you do a little bit of work. There's 3 poll questions, which you can start answering as soon as you wish. The first poll question we have for you is, have you updated your privacy policy since September 2021? And by you, I mean your organization. Second, have you reported, has the reporting of data breaches increased or decreased in your organization since 2018? That's the second question we have. And the third question is, do you have documented policies and procedures in place for dealing with subject access requests from employees? So if you don't mind, take the time over the next couple of minutes to answer that poll. We'd really welcome that. You'll find that these questions kind of permeate into some of the topics that we're going to cover today. So without further ado, we'll get going. I'm going to lead off and talk briefly about the topic of transfers. We could talk at length about transfers, but we'll try and do it in brief. Obviously, data transfers are absolutely central for commerce to operate anywhere in the world, and data transfers between the EU and the US has been the subject of a lot of news recently. But let's start with the principles. If you're based in the EEA or one of 14 Commission-designated whitelisted countries, there's free flow of personal data within those jurisdictions and countries. So that's an important starter position. If you're transferring data outside of any of those countries, well, then it's a regulated event. And the principal mode of regulation to date has been the use of standard contractual clauses, or SCCs as we call them in short. One can also rely on other mechanisms, but they're more cumbersome, such as binding corporate rules. And then there's these narrow exemptions and derogations in Article 49 of the GDPR. But again, they're kind of narrowly construed. So SCCs have been and continue to be the most popular way of transferring data from the EEA outside. Why are SCCs in the news? Well, as you saw last week, Meta was fined $1.2 billion, despite relying on SCCs in relation to data transfers supporting its Facebook service to the US, and was also given until later this year to suspend transfers to the US unless a new data adequacy decision is brought into being by the European Commission. So clearly transfers are in the spotlight, and we need to ask ourselves, so what is the story with the SCCs and what happened with Meta? And essentially that case was a further echo of the uncertainty which was kind of planted in 2020 in the Schrems II case, where the Privacy Shield mechanism was struck down by the CJEU. They said standard contractual clauses are still okay. However, if you're going to use standard contractual clauses, you need to do an assessment of the laws of the importing country. You need to identify if there's any deficiencies in terms of the safeguards in those countries for EEA data subjects, and then you need to put supplemental measures in place to seek to remedy those deficiencies. And on the back of that case, all of your organizations would have been continuing to use SCCs, and new SCCs brought out in September 2021 on foot of that decision, but then also organizations then had to start conducting transfer impact assessments to buttress and support those SCCs and put in place supplemental measures as part of those assessments. So what the Meta decision found in effect was that when it came to transfer supporting the Facebook service to the US, such were the deficiencies of US law, such was the nature of US surveillance law, that the supplemental measures put in place by Meta were insufficient. So that creates a great deal of uncertainty for all organizations. The DPC made it clear at the end of her decision, published last week, that other internet platforms transferring data to the US would be affected. And frankly, all organizations that transfer data to the US, where the importers in the US are regulated by US surveillance laws, are going to be impacted. So we've went from a pretty uncertain scenario since 2020 with transfers to a really uncertain scenario at present. So there is light at the end of the tunnel, as the DPC alluded to in her decision. A new data privacy framework is being put in place. It was announced in spring of last year, and in October of last year, the US enacted a number of new laws as part of this framework, where essentially US surveillance law will now follow EU Charter principles of necessity and proportionality. However, there's a few more pieces of the jigsaw that still need to be put in place before this data privacy framework is fully in place. And once it's in place, there'll be an adequacy decision issued by the Commission, and there will be then a great deal more certainty for organizations in the EEA who transfer to the US. As I said, there's a couple more pieces in the jigsaw, and the big question is when, and there's been a lot more indications from stakeholders on each side of the Atlantic in recent days, and the indications seem to be during the course of the summer. So we're certainly looking forward to that certainty. So what are the takeaways for you as organizations who inevitably are going to be transferring data to the US? Well, first, watch carefully for the finalization of the framework. Secondly, when the framework exists, you will have the option to certify under this new framework and under the adequacy decision with the US Department of Commerce, and that will be one way to legitimize your transfers to the US. So the question is that what I will have to do? And the answer is not necessarily. SCCs will have more fortification and buttressing once this new adequacy decision is in place. So you will be able to use SCCs with more confidence and hopefully without having to do a detailed adequacy or equivalence assessment or have a detailed impact assessment for the US, because all of that is going to be done as part of the new framework. So you'll be able to use SCCs and it'll be kind of administratively easier for your organization to do that. If your organization is transferring and using SCCs to countries outside of the EEA and other than the US, you're still going to have to do your transfer impact assessment, which is onerous, where you're going to have to weigh up the deficiencies of the laws of the importer and put supplemental measures in place. So as I said, there is lots of important developments coming up. That's it on transfers. Oisin, I'm going to hand it over to you. We got straight into GDPR there, but as Will alluded to earlier, there's lots of really interesting other developments adjacent to GDPR. Do you wouldn't mind if you want to just briefly mention?
Sure. Great to see everyone in person. So I want to focus on the new laws that are coming out of Brussels at the moment, which are likely going to impact on particularly the technology sector, but potentially are going to impact on all companies' ability to process personal data. There's a lot of laws that you've probably heard in the space. I'm going to focus on 3 of them. Those are the Digital Markets Act, the Digital Services Act, and the AI Act. So let's take each of these in turn and kind of figure out to what extent you have to care about these laws in short, because each of them runs to over 100 pages. Okay, so the Digital Markets Act, or the DMA for short. Key thing to note with the DMA is it is going to target gatekeepers. Gatekeepers are special organizations. They are effectively big tech, and an organization has to be designated as a gatekeeper by the European Commission. Gatekeepers are going to be subject to a lot of additional regulation from an antitrust and, to a certain extent, privacy perspective from 6 months after they're designated. One of the big restrictions on gatekeepers is that their ability to transfer information between different parts of their business, between different services, will be restricted absent GDPR standard consent. There's also going to be certain obligations on gatekeepers to share additional information, particularly with advertisers, to monitor ad performance. So what's the key takeaway with the DMA? If your organization is designated a gatekeeper, there's going to be a huge amount of work in this. If your organization is not a gatekeeper, the DMA is of intellectual curiosity, but it's unlikely to directly impact on your organization. Okay, so that's the first law, that's the DMA. Second law, the Digital Services Act, or DSA for short. The main thing the DSA will focus on is the regulation of content, and there'll be a lot of quite specific and prescriptive rules around notice and takedown frameworks. I'm not going to talk about those because we're going to have a different workshop in a few weeks to run through those, as Will alluded to. But I want to mention one of the lesser known components of the DSA, which is the fact that the DSA sort of supplements certain aspects of the GDPR. I kind of read these provisions of the DSA as the European legislator going back and doing things they wished they did with the GDPR but never got around to. So there's 3 kind of obligations in here that I think are particularly noteworthy and I want to flag from a privacy perspective. The first is that there's going to be a ban on targeted advertising by online platforms that's either 1, based on the profiling of minors, or 2, that is based on special category data like ethnicity, genetic information, etc. So there's going to be a kind of an advertising ban for certain types of ad activities that will apply to online platforms. The second provision, which is a really open-ended one, and I think is actually going to lead to a lot of litigation, is that there's going to be an obligation on online platforms to, quote, put in place appropriate and proportional measures to ensure a high level of, among other things, privacy of minors. Now, that's a very, very vague requirement. You have to ensure that you've measures to have a high level of privacy for minors. It's sort of I see this as almost a codification at a statutory level of the DPC's fundamentals requirement, but it's going to be very interesting to see how that's going to play out in practice, because it's clear now that there's going to be this requirement for further protection for minors' data. Then the third area where the DSA will impact on privacy is around recommender systems. Recommender systems are effectively things that, to select the sort of content you see on an online platform or determine the order in which that material will be presented. There's going to be a requirement now to explain in companies' T's and C's how the recommender systems operate, what are the main parameters that determine what content is shown. You also will have to explain any options around altering those parameters. And for certain types of online platforms and certain search engines that are the imaginatively titled very large online platforms and very large search engines, they will have an obligation to provide a non-profiling alternative. That means that when the DSA comes into effect, certain companies that have relied on profiling will have to give you another way of recommending content without profiling taking place. Okay, so what does this mean in practice for most companies? Well, these requirements are likely going to kick in February of next year. But what I would suggest is if you are kind of concerned about any of these obligations, I think the starting point is to figure out whether your company is subject to them. These rules aren't going to apply across the board. They're going to apply to so-called online platforms. Online platforms are companies that effectively store and disseminate data on behalf of users. So, again, these are quite prescriptive obligations, but unlike the GDPR, their scope of application is likely to be somewhat narrow. Okay, so that's the second law, and you probably see a theme here that there's additional kind of supplemental obligations, but they're only going to apply to some types of companies. The third law in the pipeline is the AI Act, and this is probably the most exciting or interesting one. At the moment, the use of AI is principally regulated by GDPR because it's the use of data in the AI that's regulated. AIs themselves don't really have any regulation under EU law. Now, the AI Act has not yet been adopted. It's getting a lot of political attention secondary to the rapid pace of technological development in this area, but it's still under debate in Brussels. The latest information we have is that we're looking at probably a Q3 passage of the law, and then it's likely going to come into effect 2 years thereafter. So we're looking at late 2025 before this bites. But what does the AI Act actually do? Well, a lot of things, but I want to kind of highlight kind of two sets of regulations in it. The first is that certain types of AI activities, particularly high-risk AIs, are going to be banned. And these are things like, there'll be certain activities that are a level above high-risk AIs that will be banned, and these are things like credit scoring, or social credit scoring. Then there's going to be additional obligations imposed on so-called high-risk AIs. These are a fairly diverse group of AI applications that will range from things like the deployment of AI in critical infrastructure to certain use of AI for HR purposes and also certain uses for credit scoring and financial services purposes. There's also something of an open debate at the moment as to whether or not general purpose AIs like ChatGPT will be regulated as a type of high-risk AI. The key takeaway is that if something is deemed to be a high-risk AI, it's effectively going to be regulated like hardware and not software. Now, what do I mean by that? Well, if you think of the standard business model for a software company, you create the minimum viable product, you push it out on the market, and you iterate, you make the software better over time. In contrast with hardware, the thing has to work before it goes on the market. Nobody wants a car that's only got 3 wheels and the developer adds a wheel a few weeks later. So what we're going to see now is that AIs, high-risk AIs, are going to have huge amounts of risk documentation requirements, and they're also going to have to go through a so-called certification process, so they will need pre-approval before they're deployed on the European market. So what does this actually mean in practice? So what should you do if you kind of have an AI proposal land on your desk? And I have to say, over the last 8 weeks, I've seen numerous AI proposals land on my desk because everything is being rebranded as AI for funding purposes. I think, what I would suggest is don't worry too much about the AI Act for now. If you're getting an AI technology proposal, it's going to go back to first principles, look at it from a GDPR perspective, look at it from an IP and contracting perspective. But you still should be aware about the AI Act in the background. And I would ask yourself 2 questions if you're looking at one of these proposals. The first is whether the proposed deployment of the AI could be seen as high risk. And you'll need to track what's going on with the AI Act to keep on top of that because it changes every few weeks. And then the final thing you should ask yourself is what assurances are you going to get from your service provider that they will work with you to ensure that their product will remain lawful in the EU or that they will continue to provide, that they will get the necessary certifications. So, those are the sorts of things you should be looking for in a contract, sort of assurances that your AI provider will work with you to make sure the product will remain lawful after the AI Act comes into force. Okay, so that's a lot of kind of future gazing. Let's bring it back to something that's very applicable today, which is the whole area of transparency and privacy policies. I know, Phil, this is an area you've seen kind of a lot of developments in over the last year or two. So to provide an update in terms of what are companies doing, what does the DPC expect?
Sure. The reason we want to cover this in brief is there's a great deal of non-compliance in relation to transparency and privacy policies across all sectors at present. And that's despite the fact that all of you are saying, well, we probably have a privacy policy or a few of them in place in our organization. Most of them are not compliant. And second relevant point is they're a real target for the DPC because they're limited in terms of their resource, in terms of their investigation abilities. It's easy to single out an organization and just go and look at their privacy policy. So it's kind of like low-hanging fruit. It should be easy to get right. But what we've learned in the WhatsApp decision, which was handed down by the DPC in September 2021, is that the standards expected by the DPC in terms of privacy policy compliance are actually far higher than we all originally anticipated 5 years ago when we were up here talking about privacy policies. And for that reason, as I said, it's quite likely that unless you've revamped your privacy policy in the last 18 months, it may not be compliant with the GDPR as interpreted by European regulators. Why do we say that? Or I suppose the better way of asking it is, what did the WhatsApp decision and what was this new standard interpreted? What was handed down by the DPC in that regard? The first thing they focused on was the form. And up to then, and still today, lots of organizations don't have a single privacy policy, but they have a document that links off to many other documents. While that's not unlawful, the WhatsApp decision made it very clear that if you're going to interlink with other documents, it has to be very user-friendly and very easy to navigate. And if that linking of various documents makes it quite hard to navigate, well, then you're going to have a problem and you're likely going to be found to be in breach of Article 12. In terms of the next issue is, who does your privacy policy speak to? And reflexively, organizations often get this wrong because they go, well, look, our cohort, we want to speak to those to whom we sell to. So they're speaking to customers, right? And that's fine, and then your privacy policy should speak to them. But your website is going to have non-customer visitors, or other organizations will have something called non-users who can use some services without registering. So it's really important that your privacy policy speaks to your core audience, but also these peripheral audiences as well. So that's another important learning of recent developments. But the most important thing, and the reason why we're actually doing a great deal of work revising privacy policies at present, is the level of granularity expected by regulators, which we've learned from the WhatsApp decision. And when I mean granularity, it's describing the different legal bases you rely on and linking them to the processing operations you carry out, and in turn linking them to the different categories of data that are being processed pursuant to these different operations. So it's kind of like a data map. And the privacy policy can no longer just go, we rely on the 6 legal bases and recite Article 6, and we process all of these categories of data over here. That just won't work. That will be unlawful. So in order for a privacy policy to be lawful, far more work is required. You have to look at the various processing operations and purposes of your organization, and you need to track that to the different legal bases you're relying on and link it in turn to the categories of data you're processing. Quite an onerous task. As I said, enforcement is happening. It has happened in WhatsApp case. DPC's annual report cites a number of large organizations, Yahoo, Google, TikTok, who either directly or indirectly are the subject of transparency inquiries, as are a number of domestic organizations. So it is a real significant risk area. As a consequence, as I said, we're doing a great deal of work in the area. So, I mean, the takeaway for today is awareness. Do understand there's a good chance the privacy policy organization uses may not be up to scratch given recent developments. And secondly, the exercise of redoing a privacy policy involves quite a bit of introspection and mapping of data flows within your organization. But the beauty of the exercise, in addition to having a compliant privacy policy at the end, it helps unearth a lot of other issues in your organization when it comes to privacy compliance. So it's a great exercise, not just to get your privacy policy in place, but to anchor a kind of a 5-year anniversary GDPR compliance project, because it tends to unearth a lot of other issues. That's it on privacy. Moving along to a more sort of latent and stealth principle, which also came out of the GDPR in 2018, the principle of accountability. Oisin, do you want to share some thoughts on that 5 years on?
Yeah, absolutely. So accountability is something organizations, I think, really struggle with under the GDPR, even though, as everyone's said a few times, we're kind of half a decade into it. What is the accountability principle, I guess, to start? Well, there's a requirement under the GDPR that not only do you have to comply with the law, but you also have to demonstrate that you're complying with the law. I actually sometimes refer to this as the presumption of guilt. And the analogy I often draw is that if, a guard pulls you over because you're speeding, the obligation is on them to show that you were in fact over the speed limit. In contrast, with the GDPR, if the DPC rocks in, they don't really have to prove that you were breaching GDPR. The onus is on you to prove that your compliance, it's to prove that your processing was in compliance with GDPR. So you have this kind of overarching principle. It manifests itself in a couple of ways, but perhaps one of the big ones is the requirement to maintain records of processing activities, or so-called ROPAs. These are documents that effectively detail all the different ways in which the company is handling personal data, and these are internal docs rather than external ones. Pardon me. Now, last year, the DPC did a large sweep of companies, both domestic and international, based in Ireland, to basically ask for their ROPAs to see, whether or not they were compliant. And then, as a result of that, the DPC released guidance a few months ago on this topic. Now, the DPC's guidance is quite interesting. It's helpful in some respects, but keeping with the theme that we constantly see, there's a very high standard being imposed by the regulator here in terms of what companies are expected to do. One of the big takeaways from this guidance is that there's this requirement that ROPAs have to be very granular. They have to be specific. They have to identify exactly what data is being processed and for exactly what purposes. So sort of generalized statements will not work in a ROPA. You're talking about a pretty detailed spreadsheet, to be honest, to have anything that's actually going to be compliant here. There's also kind of an interesting point in this guidance that has not gotten much attention, so I want to flag it, which is the scope of the ROPA derogation. Now, there is a provision in the GDPR that says that if a company is an SME defined as having less than 250 employees, it doesn't need a ROPA absent certain situations arising. So in practice, most SMEs do not have ROPAs in place because it's quite a technical compliance document. But the DPC looks at this derogation and actually is interpreted in quite a narrow way. And the regulatory guidance is that the derogation does not apply insofar as any processing you're engaging in creates a risk for data subjects, and the DPC says this would include things like deploying AI. And then crucially, the DPC says that even an organization, regardless of its size, will need a ROPA if in relation to processing which is not occasional. And they define this in particular by reference to staff information or HR records. They also say that you will need a ROPA if you're processing any special category information, which would include such things as sick notes on employee files. So I guess, a point to note here is that basically every business, every organization, regardless of its size, is going to need a ROPA, at least for those activities that cannot avail of a specific derogation. Another point that is kind of quite pertinent from this guidance, and you got the impression that this was a practice that the DPC saw a lot of and it was quite annoying them, is the idea of linking documents out from ROPAs. Because one thing that's often done is you will have a record of processing activities, and then there will be a chart or a column saying things like retention period or security measures, and then there will be a reference off to other external documents, such as the general corporate security policy or a separate retention schedule. The DPC says that doesn't work. They want the ROPA to be a full freestanding document that they can look at and understand by itself. Related to this, the DPC was very clear that they, as part of the sweep, they noticed that a lot of companies were struggling to produce ROPAs within the 10 days that was originally being prescribed. And they've effectively put everyone on notice to the effect that they expect every company to be able to produce a fully up-to-date ROPA hitting their standards within 10 days of the request going in. So I guess, there's a bit of a kind of shots fired across the bow here, and that there's clearly an expectation that organizations will be able to, provide these documents, which in turn means they're going to be creating them and keeping them up to date over the course of the year. I feel like I'm the bringer of bad news, so I'm going to flag one piece of one useful development in the area of accountability, which is a little-known decision from the CJU called UZ v. Deutschland, and that is a recent case that basically considered what are the consequences of a breach of the accountability principle. And at issue in these proceedings was whether or not a failure to have ROPAs in place or a failure to actually comply with the accountability principle would render the underlying processing unlawful. So the concern here was that the processing by the German state hadn't complied with the formality requirements, and the question was, does that make all of the processing unlawful? Thankfully and helpfully, the court said no, these are two separate sets of requirements. So if you get your documents wrong, it doesn't mean that you've broken all of the GDPR substantive requirements, but you still have an issue with respect to that, with respect to those accountability obligations. So you can the court's way of conceptualizing this is you have your substantive obligations, and then you've got your accountability obligations, and they are actually separate and distinct, which is somewhat helpful. Okay, and then I guess kind of bringing it back home, with the final topic we want to talk about today, and one that I get asked about a lot, is the whole area of civil damages for data protection claims. And this got a lot of attention about 5 years ago, hasn't really gotten much momentum so far, but there have been a few developments here over the last year we want to flag. So, Bill?
Yeah, thanks, Oisin. Yeah, I mean, I just want to mention the whole scope of the compensation right. And the big question is non-material loss, because invariably if there's a security breach of some sort or a privacy infringement, more often than not, there's not actual loss, but often it's psychological harm and non-material loss. And the question is, well, what sort of standard of proof exists? I'm afraid I don't have a clear answer for you yet, because the law is evolving still. A couple of quick points to note. One of the first cases to be heard on this finally made it to the Circuit Court last year. It concerned a number of employees of SIP2 whose data had been compromised in a security breach whereby their email addresses and their names and certain other details were shared with other SIP2 members via a security breach, and they took a claim in the Circuit Court. They were unsuccessful. They failed to show sufficient harm for the judge to think that compensation was warranted. And the judge said that proof of more than minimal loss was required, and they ended up having to cover their costs in that litigation. Since then, there's a couple of sort of class action type cases weaving their way through the Irish courts, including one concerning the HSE infringements. However, since earlier this year, they've all effectively been stayed, subject to 6 cases being heard by Europe's highest court. So there's actually quite a queue forming now in terms of these cases. And that makes a lot of sense, because there is a lot of cases, as I said, in Europe's highest court, in the process of being decided, which are going to decide this standard of non-material loss. Of those cases, only one of them has been decided now, and that's the Austrian Post case, which was handed down earlier this month. It hasn't it's just handed down a piece of this jigsaw, so to speak. And really what it has said is that there must be some type of harm in order for a plaintiff to succeed in an action. However, they didn't prescribe a standard, and it said it can be quite a minimal standard. So they essentially said that there must be harm, and there must be causation. The harm must flow from the damage. And they simply said, but it can be a de minimis standard. So that's kind of left people wondering, what does de minimis mean? Is mere upset or a bad feeling about a breach sufficient? More recently, just last week, an Advocate General's opinion was handed down in another of these 6 cases, and that kind of is like handed down another piece of the jigsaw. And the focus of that opinion was quite interesting, because it looked at the causation and the damage, and it said the wrongdoer, the organization that caused the breach, the nature of its default is not relevant to ascertaining the quantum of damages in the claim. So there's no need for intent. There's no need for negligence, and really the default itself does not fall for examination in computing what the compensation will be. So that's rather useful to know. So what we're doing is, we're in these cases, and there's a couple more going to come through the CJEU system this year, are kind of giving us further clues. We're getting a better picture in terms of what that standard of harm is, but we're not there yet. Do expect that it will be quite a low standard, and I suppose we just have to watch this space. The only other observation at this stage is that insofar as other jurisdictions are hearing cases and deciding cases and awarding compensation for non-material loss, the quantum has been very low. So that's useful for organizations to know. And as I said, hopefully next year when we're sitting up here, I'll have a few more pieces of the jigsaw when these next CJEU cases are handed down on this topic. So that really concludes it. We're out of time, Oisin, so we don't have time for questions, unfortunately. What I'm gonna do is just move on to the next module, if that's okay. And I'm delighted to introduce you to 2 other partners from the privacy and security team. That's Brian Johnson and Julie Austin. And Brian and Julie are gonna talk about, excuse me, they're gonna talk about security breach and enforcement. Thank you.